Members, we are going to take up items for which we passed temporarily. We are moving back in the file to file item 119. Is SJR 13. The clerk will read.
Senate Joint Resolution 13 by Senator De Leon and others relative to voting.
Members, we're going to pass temporarily again on file item 119. We're going to move to file item 140. File item 140 is SB 533. The clerk will read.
Senate Bill 533 by Senator Pan, enacting the local government.
There he goes.
SB 533. Mr. McCarty, you may open on the measure.
Thank you, Mr. Speaker and members. I rise to present SB 533, which eliminates a loophole in sales tax agreements in local governments. Local sales and property tax are how cities pay for services like police and fire, as we know. Unfortunately, this current loophole allows businesses to open a small office in a new city and take advantage of the city's lower tax rate. This allows them to leave the bulk of their operations in the same city, but avoid paying their fair share of local sales tax. This bill eliminates this loophole and stops this practice. I respectfully request your aye vote.
Thank you, Mr. McCarty. Seeing no discussion or debate on this item, clerk will open the roll. I'm sorry. Mr. Obernolte, my apologies, I didn't see your microphone. You have the floor.
Thank you, Mr. Speaker. I rise in opposition to SB 533. Colleagues, it's no secret that the nexus laws governing the apportionment of sales tax revenue in the state of California are in serious need of reform. They clearly have not kept up with the times. But if we agree that these rules should be reformed, then what we ought to do is support legislation that implements a comprehensive reform of the laws. What we should not do is support legislation that takes a piecemeal approach and pits our cities against each other, creating winners and losers, as this bill does. I urge a no vote.
Thank you, Mr. Obernolte. All debate having ceased, Mr. McCarty, you may close if you wish.
Respectfully ask for your aye vote.
Clerk will open the roll. All members vote who desire to vote. All members vote who desire to vote. All members vote who desire to vote. Clerk will close the roll, tie the vote. Ayes 49, noes 22. Measure passes. We are now moving back to file item 119, SJR 13. The clerk will read.
Senate Joint Resolution 13 by Senator De Leon and others relative to voting.
Mr. Gomez, you may open.
Mr. Speaker and members, thank you for the opportunity to present SJR 13 on behalf of Pro Tem De Leon. We are deeply concerned by the inexplicable decision of the United States Supreme Court to hear a challenge brought by plaintiffs in Texas to the long-standing democratic principle of one person, one vote. Since it was first affirmed 51 years ago by Chief Justice Earl Warren Supreme Court, one person, one vote has been a widely articulated and consistently upheld tenet of our nation's Constitution. Before that time, political districts across the nation were arbitrary and imbalanced, and millions were underrepresented. Los Angeles County and its 6 million people, for example, had the equivalent voting power in our state Senate as one district with barely 14,000 people. This challenge now is nothing new and nothing than a cynical and transparent effort to turn back the clock on decades of legal precedent and return an unjust, unequal system of redistricting that could greatly disadvantage diverse and urban communities and deprive millions of American residents, many whom are either Latino or Asian, of political representation. In California, overturning one person, one vote could lead to a system of political segregation that only counts 3/5 of our population and essentially ignores the rest. This resolution makes it clear to the Supreme Court of the United States that Californians believe that all people, not just adults who can register to vote, deserve equal protection under our laws and fundamental political representation. I ask for your aye vote.
Thank you, Mr. Gomez. Mr. Ridley Thomas, you are recognized.
Yes, thank you, Mr. Speaker. Colleagues, I rise in support of SJR 13. As the gentleman from Los Angeles has indicated and the author stated in his presentation before the Elections Committee, one person, one vote is a fundamental tenet of how we operate our democracy, a representative democracy. I would add that from the federal perspective, if the one person, one vote rule were to be eroded, California would significantly suffer from that change, because districts across this state enjoy their size, their composition, their political representation because of the underlying population, which is the correct, in my perspective and many others, interpretation of one person, one vote. So if it were to be upended or changed significantly, it would be disadvantageous to the state across party and across region. We know we have significant population challenges. We have significant mega regions that require adequate funding and proportional representation, and one person, one vote is actually an advantage to this state as it is currently operated. So any threat to that undermines all of us. It is more than party. It is more than region. It is more than ideology. It is simply proportional and fair representation. We don't want to be in the situation that we found ourselves in, that Mr. Gomez mentioned, where we have one county with a state senator who at the time represented 6 million people versus, in this case, it would be, if one person, one vote were to be eroded, it would be states outside of California where they had smaller populations, lower population numbers, but had actually proportionally more representation. With that, I would respectfully request an aye vote of SJR 13 and thank the gentleman and the author for bringing it forward. Thank you, Mr. Speaker.
Thank you, Mr. Ridley Thomas. Mr. Wagner, you are recognized.
Thank you, Mr. Speaker. Let's be very clear. The venerable principle of one person, one vote is not under attack in the Evanwall case that the Supreme Court is hearing. It is not challenged. It is a bedrock principle that everybody on this floor, indeed, everybody with a stake in our democracy can appreciate. I am, however, somewhat amused to hear the authors attempting to support this resolution with reference to legal precedent. Let's go through the legal precedent, shall we, and see what one person, one vote is getting at. And let's be clear at the outset. The issue of one person, one vote is not up for debate. The question is, who do you count when deciding how you're going to draw your districts? Do you count, for example, those who are not here legally? Do you count felons who've had their right to vote removed? Do you count children? The answer historically, the answer under all of the legal precedent from the Constitution on down has been no. You count citizens. The 14th Amendment. No state shall make or enforce any laws which shall abridge the privileges or immunities of citizens. It goes on to draw a distinction between persons. You may not have your life, liberty, or property abridged. Citizens are specifically called out. The 15th Amendment refers to the right of citizens of the United States to vote shall not be abridged or denied on account of race. Citizens. The 19th, the 24th, the 26th Amendments provide for the right of citizens. This resolution completely ignores that, and it says, wait a minute, we're going to ignore that, but we're going to rely on the United States Supreme Court's case of Reynolds versus Sims. You'll see the Reynolds case referenced 5 or 6 times in the resolution, all right? Let's turn to Chief Justice Warren's opinion in the Reynolds versus Sims case. Permission to read from that case.
Without objection.
Thank you, Mr. Speaker. According to the great Chief Justice, in the minds of some on the left, quote, all who participate in an election are to have an equal vote, whatever their race, whatever their sex, whatever their occupation, whatever their income. That's what the Evanwell case is trying to get us back to, and that's what SJR 13 opposes. Continues Chief Justice Warren, former governor of this state, quote, "It is inconceivable that a state law to the effect that in counting votes for legislators, the votes of citizens in one part of the state would be multiplied by 2, 5, or 10, while the votes of persons in another area would be counted only at face value. It is inconceivable that that could be constitutionally sustainable." He goes on, in the very case that this resolution says we got to look to, while ignoring it, he goes on, to the extent there's a citizen's right to vote is debased, he is that much less a citizen. Do not vote today for a resolution that makes some citizens that much less of a citizen. Chief Justice Warren concludes in the Reynolds versus Sims case, the overriding objective must be substantial equality of population among the various districts so that the vote of one citizen is approximately equal in weight to that of any other citizen in the state. That is what the plaintiffs in the Evanwell case are trying to get accomplished, and that's what SJR 13 is standing foursquare against. There are a bunch of other Supreme Court cases that say exactly the same thing. In Westbury, the court said, quote, "It would be extraordinary to suggest the votes of inhabitants in some parts of a state could be weighed at 2 or 3 times the votes of people living in other parts of the state."
30 seconds.
Other rights, even the most basic, are illusory if the right to vote is undermined. But wait, we're told, what about disenfranchising people? Think for a moment about the logic. No, don't think about the logic. Think about the word. You cannot, by definition, disenfranchise someone who doesn't have the franchise to begin with. The Supreme Court in Reynolds, indeed the Constitution in 4 different amendments, protects the citizens of this state and their voting franchise.
Time, Mr.
This
Wagner.
cynically undermines it. I urge a no vote.
Mr. Gallagher, you are recognized.
I must respectfully rise in opposition to this resolution because it is a contradiction in its terms. We're talking about one person, one vote, and people are throwing out that concept and those words without talking about what it means. And the bottom line is, if you support one person, one vote, then you need to oppose this measure. Because the concept of one person, one vote was established in the case of Reynolds versus Sims, and it says exactly this: an individual's right to vote for state legislators is unconstitutionally impaired when its weight is in a substantial fashion diluted when compared with votes of citizens living in other parts of the state. But that's exactly what happens when you count non-citizens when you draw your districts. You dilute the votes of other districts and other voters in other parts of the state who don't have as high a percentage of non-citizen residents living in their districts. You in effect dilute and disenfranchise those voters. That's inconsistent with one person, one vote. A similar type of concept was tried by the southern states. After the Civil War, the southern states said, yes, okay, we want our districts to be counted up based on population, and they wanted to count former slaves, who they purposefully had made it so they could not access the franchise, so they could not vote, but they wanted to count them for the purposes of getting more districts, more voting districts in their states. The 14th Amendment directly dealt with that and said, no, you will not be able to count those people unless you give them the right to vote. Read the 14th Amendment, Section 2. It directly addressed that issue. Well, that's the same situation we have right now if we do not apportion seats based on those who are eligible to actually vote. So I would encourage my members to really look at this and realize that this is a contradiction in terms. You cannot be for one person, one vote, and also support this resolution. And in fact, I'll do a question of the author, because I think this really lays it out.
Without
and
objection.
This is my question. My question is, do you support the right of non-citizens to vote? If you answer yes, then you turn our whole idea of citizenship on its head. If you answer no, then you're not supporting one person, one vote, because you're saying these people don't have the right to the franchise.
Mr. Holden, for a purpose.
Mr. Speaker, the Speaker has not framed his question. He said he wanted to ask a question, but he has not framed a question. I ask that he be directed to frame the question and not add a lot of extra words to his statement.
Mr. Gallagher.
The question is, do you support non-citizens having the right to vote in California?
Mr. Gomez may answer that in his close. Mr.
May I finish?
Mr. Gallagher.
And in answering that question, if you answer yes and say, yes, I support the non-citizens having the right to vote, then we stand our whole concept of citizenship on its head, which says that only those who are citizens can vote, who have gone through the process of citizenship, have the right to vote. If you answer no, then you can't support this resolution, because what you're saying is you want to count those people for the purposes of getting more representation in your area, but you don't want to give them the right to vote. You're in a quandary. So I would ask members to really think about this resolution. Thank you.
Mr. Alejo, you are recognized.
Thank you, Mr. Speaker and members. Frankly, in a year that we're celebrating the 50th anniversary of the Voting Rights Act, just last month, and my colleagues from both sides of the aisle stood up and made comments about supporting voting rights, making sure that minority voters were not disenfranchised. Here, two of my colleagues making some unconscionable statements about a case that is before the Fifth Circuit Court that will be heard this fall, that will be decided probably by next June by the U.S. Supreme Court. But for the first time, we'll challenge the one person, one vote, the apportionment aspect of our congressional districts. And why does this matter? Because each of us, every single person in this chamber, represents citizens and non-citizens alike. I don't know about you, but when somebody comes to my office, I don't ask, are you a U.S. citizen? If they have a problem with the state agency, if they have a problem about a highway that needs repair, about a project because too many people were dying in your district, we don't ask, are you a citizen, are you a voter or not? We represent everyone equally. So it's an insult to hear that somehow only citizens would matter in terms of having a representative. We don't do that. None of us do that. We respect everybody because we know they're hardworking residents of our community, and not supporting this sends a message to them that you think that their concerns don't matter, that they shouldn't have a representative in the Assembly or the Senate or in Congress. It's an insult to your constituents to hear those kind of comments on this floor. And my colleague, we both went to King Hall, Martin Luther King Hall, and one of the first cases that we hear in our constitutional law class is Reynolds versus Sims, one person, one vote, that was decided in 1964 during the height of the Civil Rights Movement. The Civil Rights Act was passed in 1964. The Voting Rights Act was passed in 1965. And yet, here's a case before us that could disenfranchise millions of people all over our country, and I think it's almost like 37% of the residents of California. And we're not just talking about undocumented, because anyone who's worked in immigration law will tell you that there's a lot of categories of immigrants. We're talking about lawful permanent residents. We're talking about asylees. We're talking about people who came under special relief for Cubans or Haitian immigrants. A lot of categories of immigrants that with this case, and by not voting on this resolution, you're telling your constituents that they don't deserve a representative. That's unconscionable. That's wrong. And along with this, a lot of other rhetoric going around across the nation with people saying they should deport millions of immigrants and their U.S. citizen children. It's unconscionable to hear that. Often we hear colleagues cite the Constitution, that we should be following the Constitution. Well, this has been decided long ago about the 14th Amendment, equal protection under the law for everyone. And even in the 14th Amendment that was cited earlier, it actually says representatives shall be apportioned among the several states according to their respective numbers, counting the whole number of persons in each state. It doesn't say citizens. All shall be the whole number of persons in each state. And it was interpreted by the Reynolds versus Sims, by our highest court. And now, conveniently, when a conservative group in Texas wants to disenfranchise immigrants, all of a sudden we want to forget about the 14th Amendment and interpret it in a different way. I find that appalling, and everyone should support this for all your constituents, whether they're citizens or not.
Thank you, Mr. Alejo. Mr. David Chu, you are recognized.
Thank you, Mr. Speaker. Colleagues, I wasn't going to speak during this discussion, but as a former civil rights attorney, I do feel compelled to state the record straight on a number of things. First of all, it was suggested that 50 years ago in the Reynolds v. Sims Supreme Court case, that somehow stood for the premise that we should not consider our immigrants as far as a population count. And let me just cite the most famous line from that Reynolds v. Sims case. Chief Justice Warren stated that legislators represent people, not trees or acres. I happen to be one of the members of this body who think that regardless of your immigration status, you are a person. There may be some in this room who may disagree with that statement, but I happen to think that that's the case. And let me further state that the key ruling in that Supreme Court case was that the population must be addressed when it comes to these considerations. Again, I happen to think that immigrants, regardless of your immigration status, should be considered in that population. We know that the context 50 years ago for this jurisprudence came on the heels of a history of African Americans being considered to be 3/5 of a person for purposes of apportionment. And colleagues, if the Supreme Court goes one direction with this case, we could see literally almost 40% of the population in our state being disenfranchised, the bringing back the 3/5 rule into our Supreme Court jurisdiction. And I would like to take an opportunity and respond to our colleagues from Nicholas's point around whether non-citizens should have the right to vote and correct you on one other point of history. It is actually true in our U.S. history, under the Supreme Court, for 150 years, non-citizens were allowed to vote. The Supreme Court has repeatedly held that citizenship status is not essential to the vote. What's important is whether states or localities grant that right to vote. In fact, that was the case from the beginning of our country's history until the 1920s. And who was allowed to vote? It was actually white European property owners, regardless of citizenship status, who were actually granted the right to vote. And in fact, over the last 30 years in the United States, New York City, Chicago, several cities and towns in Massachusetts, several cities and towns in Maryland have allowed immigrants to vote based on this Supreme Court jurisdiction, based on the sense that we need to be inclusive, particularly at a time when we have millions of residents who are not citizens because of a failure in Washington, D.C. for certain legislators to be able to move forward and put together comprehensive immigration reform. So with that, I'm a strong supporter of this measure. I think we need to do it. I think it will dramatically change the face, not just of what our state is about, not just what our country is about. It will send absolutely the wrong signal about who we consider as people, who we consider as part of our population, and who it is that we serve.
Thank you, Mr. Chu. Mr. Chavez, you are recognized.
I really enjoyed the whole discussion we're having here, and I'd like to also recognize that the previous speaker highlighted, I think, some good historical context to it on the issue of voting. As we know, through the history of our country, we've changed actually who can vote, as he was outlining. But what's before us today, let's be truthful about this. What is before us today is how as we as a country are going to deal with immigration reform. This isn't about voting. This is about immigration reform, and we've had a lot of discussions on who's going to get health care, who's going to get education, who's going to have a driver's license, who's going to be on a jury, who's going to vote. You know, this body has come together very strongly in a bipartisan way to the nation to say, let's have immigration reform. Let's find out who's here for all the different reasons. But we should not go into areas until we define that. That's why I am not supportive of some of the initiative in health care, and that's why I don't think we ought to be supportive of this. Because voting is central to our country. It's a good discussion. It has changed historically, but we're setting a precedence for the future. Something that we can deal with once we deal with immigration reform. I'd ask everybody to sit back and reflect on this, understand the politics behind it, thinking about what is a district, how many voters are actually in my district, what could I possibly gain from this, and think of the larger picture of how do we move society forward in a very thoughtful, direct way. I think this JJR right now is not appropriate. I'd ask for a no vote.
All debate having ceased on the resolution, Mr. Gomez, you may close.
Thank you so much, Mr. Speaker, and thank you to my colleagues who spoke in favor of this resolution. I think this resolution really is a statement of where we're going as a country, and also what we didn't accept as a country when it came to our history. I love the minority party sometimes likes to stop history when Lincoln became president. Right? They don't go all the way back to the beginning and understand the fundamentals of what does being a citizen or an individual in this country. When you point out that the southern states wanted to count people as 3/5, that's because they were viewed as property. But I didn't hear him say that, right? He didn't want to point out that the African Americans and blacks were considered property during the early part of our history, but they still wanted to count them in order to get a bigger percentage. But what can I do? I can't point out those fallacies at times. So they don't want to acknowledge where we've come. It was white men who owned property. Then white men who didn't own property. Then it became the 14th, the 15th, and the 16th Amendments. Then it became the Civil Rights era with the Voting Rights Act. Then it became the abolition of the poll tax, and then test at the polls. You name it. We've had to do a lot to try to create an equal playing field, an equal society where people do have a right to vote. However, we need to continue to acknowledge that we represent everyone who's in our district, not just the ones that are 18 and over and citizens. How many of you have introduced bills that deal with children or immigrants? It's because we understand that we have a responsibility to everyone in our district. I have 9% Republican voter registration in my district, 9%. However, when they call and they want to meet, I still meet with them. I don't say, you know what, you represent 9% of my district, I don't need to meet with you because I already have 91% of my folks with me. Right? That's not what I do. I represent everyone. So when we're looking at the idea of one person, one vote, it's to reaffirm the fact that we have to represent everybody in our district, and everybody is protected under the law. Moving forward, we have to decide on other issues. There's some people on the minority party side that believe that birthright citizenship should be repealed, right? That would mean that pretty much myself and maybe a few of our other colleagues would not be considered citizens. Is that the next step? Is really that the next step? I do find it offensive because I feel just as American as apple pie and salsa, right? So, in the end, I'm asking everyone to vote for this. I'm also asking the minority party to vote for this, because if you vote against it, you're basically saying that you have not left 1994. I ask for your aye vote.
Thank you, Ms. Gomez. With that, the clerk will open the roll. All members vote who desire to vote. All members vote who desire to vote. All members vote who desire to vote. The clerk will close the roll, tally the vote. Ayes 51, noes 11. Resolution is adopted. Okay, members, we are moving to file item 172. That's SCR 83. The clerk will read.
Senate Concurrent Resolution 83 by Senator Welk and others relative to the International Year of Soils.
Mr. Gallagher, you may open.
Members are as in support of SCR 83, which would declare 2015 as International Year of the Soils. As we know, 95% of our food here in California is directly or indirectly produced on our soils and the essential nutrients that they contain. We also know, more importantly for us in these times, is that ensuring healthier soils and improved soil health increases soil's water holding capacity and the water infiltration rate, which can help optimize the management of California's scarce water supply. So I ask you to support this SCR to recognize the importance of healthy soils as a critical resource supplying an abundance of food, diverse habitats, water storage, and climate resiliency. I ask for your aye vote. Thank you.
Mr. Gallagher, would you like co-authors on the item?
Ask that the roll be open for co-authors.
Very good. Mr. Gallagher is asking the first roll be open for co-authors. Members on SCR 83. Clerk will open the roll. Members, this is for co-authors. Adding on SCR 83. Co-authors, members. The clerk will close the roll. There are 68 co-authors added without objection. We may take a voice vote on the resolution. All those in favor say aye. Aye. Opposed say nay. The ayes have it. The resolution is adopted. Members, I am again prepared to lift the call on Senate Bill 230. Clerk will post. All members vote who desire to vote. All members vote who desire to vote. All members vote who desire to vote. Clerk will close the roll. Tally the vote. Ayes 41, noes 34. The measure passes. Members, we are moving to announcements and adjournments in memory. If we could have your respectful attention, members, for these adjournments in memory. The following members were granted prior permission to speak on an adjournment in memory. Members, please take your seats. Please take your seats, members. Please take your seats, members. Members, please take your seats. Members, please keep your comments to 2 minutes. Mr. Cooley, you are recognized for your adjournment in memory.
Colleagues, I rise today in memory of Nathan Sparks, a longtime resident of my Assembly District who passed away the week of our adjournment in the summer. Nathan Sparks lost a courageous 3-year battle with pancreatic cancer on July 13th, 2015. Nathan was born in 1935, October 17th, to Fenton Hesper Sparks in Northport, Alabama. He was the oldest of 4 children. After attending business college in Nashville, Tennessee, he joined the United States Air Force and served 26 years there, touring in Vietnam, England, Germany, and Italy. He retired in 1984 as a senior master sergeant, but then went back to work for the United States in the Department of Defense, and worked as a civilian before he retired from that career in 2001. Here in the Sacramento region, Nathan was 10 years on the board of the Rosemont Community Association, serving 9 years of those as treasurer to ensure the fiscal well-being of the community in which he lived. He volunteered on nearly all projects to improve his community, including leading cleanups of Kiefer Boulevard, a key arterial for the residents of Rosemont, and did that for years. He enjoyed traveling, taking many cruises with his wife to many different parts of the globe. With his affectionate smile, Nathan found it easy to make new friends, and he was always willing to lend a hand. Spending time with his 4 grandchildren was his greatest joy. Nathan is survived by his wife, Uta, his daughter, Tanya, his grandchildren, Dakota, Austin, Trenton, and Callie-Ann, his sister, Lena, his brother, Thomas, Johnny, his brother-in-law, and his many nieces, nephews, aunts, uncles, and cousins. Nathan was preceded in death by his parents, his sister, Joyce, and his brother-in-law, Henry. I ask that we adjourn in his memory today. Thank you very much.
Thank you, Mr. Cooley. Mr. Dodd, you are recognized at your desk.
Mr. Speaker and members, I ask you to join me today in remembering and celebrating the life of John Michael Larson of Davis. At 26 years old, Michael was an insightful and intelligent young man known for his love of wilderness, photography, and filmmaking. Michael worked for the state for 3 years, starting in 2010, first as a Capitol Fellow for the executive branch, and later the California Growth Council. You know, it's really interesting. I did get to know Michael as he was the campaign director of one of my opponents in the last race, and he really made an incredible impact on me, just the way he handled himself from start to finish, before, during, and after that campaign. Michael is survived by his wife, Carolyn, his parents, Gary and Sandra, as well as his sister, Erica. Our thoughts are with Michael and his loved ones. Thank you for this adjourned memory.
Thank you, Mr. Dodd. Mr. Gibson, you are recognized.
Thank you very much, Mr. Speaker and members. With a heavy heart, I rise today to request that this body adjourn in memory of William Theodore Kemp, Jr. William Jr. was born on December the 14th, 1989, to William and Danielle Kemp. Less than 2 weeks ago, William and his younger brother, Joel Williams, were involved in a serious car accident. After fighting for his life for over 4 days, William Jr. succumbed to his injuries on August the 18th of this year. William Joel, the youngest brother, is 18 years old and still in critical condition today, suffering from serious brain trauma, internal bleeding, and fractured vertebrae. I ask that we pray for his family, that he receive a speedy recovery. I would also ask all the members that you should certainly grab your loved ones and tell them how much you appreciate them. Life is still but a vapor. Thank you very much, Mr. Speaker.
Thank you, Mr. Gibson. Mr. Holden, you are recognized.
Thank you, Mr. Speaker. And members, today I rise to adjourn in memory of a personal friend and resident of Pasadena, Dr. Roby Lewis Radley. Dr. Radley was a graduate of Howard University Dentistry. He was a dentist and captain in the U.S. Army. In 1985, he received a postdoctorate in oral surgery from Martin Luther King Hospital in Los Angeles, California. He then opened Green Street Dental in Pasadena, California, where he worked tirelessly until his passing. As a philanthropist, Roby often provided free dental care to those in need, purchased books for students, and tutored students in dentistry. He also generously supported organizations such as the Urban League, the NAACP, the Democratic National Committee, and, of course, his beloved Howard University. Roby Radley received numerous accolades, including introduction to the Kappa Epsilon Honor Society in 1978, Legacy Awards from Boulay Foundation, Outstanding Service in the U.S. Army, and a Dean's Award at the University College of Dentistry. Roby had many hobbies, including horticulture and classic car restoration. His love of plants, flowers, and trees was evident by the beautiful and meticulous landscaping of his Pasadena home. He is survived by his beloved wife, Dr. Karen Gwynn Radley, his son, Blaine Radley, daughters Raven and Rachel, his sisters Donna Radley Good, Carolyn Patricia Radley, three brothers, Sammy Harris Jr., Rector Harris, Barrington Radley, nieces and nephews, and a host of relatives. I thank you for considering adjourning in his memory.
Thank you, Mr. Holden. Members, please bring the names to the desk to be printed in the journal. All requests to adjourn in memory will be deemed read and printed in the journal. The session schedule is as follows. Tuesday, September 1st, floor session at 10 a.m. Wednesday, September 2nd, floor session, 10 a.m. Thursday, September 3rd, floor session at 10 a.m. Friday, September 4th, floor session at 9 a.m. All other items remaining will be passed and retained. All motions shall be continued. Seeing and hearing no further business, I'm ready to entertain a motion to adjourn. Mr. Holden moves, Ms. Waldron seconds, that this House stands adjourned until Tuesday, September 1st at 10 a.m. Quorum call is lifted.